People say goodbye to me, which I would say to you can't. You've got to come back in. Hey everybody, my great pleasure to today's the final session of the conference. So just in case anyone doesn't know who I am by now, I'm Professor Helen Carr here at Southampton Law School and part of the People Property Community Centre, which has been the host of this event. So what I'm going to do is firstly introduce our panel and then explain the format of this event, which is slightly different. So let me start with Siobhan McGrath. She is the president of the Property Chamber of the First Year Tribunal. She studied law and became a barrister. She studied law at Sussex and became a barrister, and then realised that becoming a judge was more fun or something.
It's the power. It's the power.
It was power. But for those of you who don't know Siobhan, she actually does have aspirations to take over the university via property litigation. So I think that is worth knowing. She became the president of the Property Tribunal in 2000, and my notes say she has remained there, slowly expanding its remit, but perhaps slowly is the wrong word. Explosively expanding its remit. She sits as a recorder and as a deputy High Court judge. Yes, a massive expansion of the jurisdiction of the tribunal is underway. Leasehold is at the heart of the tribunal's work, and it is essentially the arena that will be handling the new law. So Siobhan is going to have a really interesting perspective of what the future would be. And then we've got Philip Rainey, KC, who is a specialist in property litigation and real estate litigation. He's at Tanfield Chambers, which is Chambers which specialises in property law. His practice straddles, this is all from Chambers, you know, what's the software web. Practice straddles the commercial residential divide and encompasses all aspects of real property, landlord and tenant, residential landlord and tenant, enfranchisement and service charges, and that's where he's made his reputation. So he's appeared in 9 cases in the Supreme Court and numerous cases in the Court of Appeal, and he's recently been appointed as a Deputy High Court Judge. Nick said we didn't need to introduce him, but I think for the purpose of this panel we should. Professor Nick Hopkins is a professor at UCL, but for the purposes of this panel, importantly, he was the Property Law Commissioner and led its work on residential leasehold and Commonhold from its inception in the 13th programme of the law reform, right through to the Leasehold and Freehold Reform Act 2024, and really you are witnessing the enactment of your work, which is incredibly exciting, particularly for someone who worked on a bill that was never ever enacted. I'm seriously impressed. So the recommendations of the Law Commission are really the basis of what will be the future of leasehold. So we've got people who are absolutely at the forefront of the law here today. How we're going to do it is each of them are going to speak for around 7 to 10 minutes, and then we have some carefully constructed questions which I will ask, and they will all answer those, and then the floor will be open to you. So thank you very much. I'm looking forward to this very, very much.
Thank you very much, Helen. And I say that my job as Commissioner was only possible because of the extreme generosity and intellectual input of Siobhan and Philip and others. And Siobhan and Philip were incredibly generous of their time and expertise throughout the work that we did. So I'm delighted to be on the panel with both of them today. I was amused to see that the panel called The Future of Leasehold. So I thought, well, that's quite simple. It doesn't have one. Let's all go and have coffee. We are experiencing a system change in property law and in how ownership is understood. And I think that's a really exciting thing, not only for law reformers, but for all property lawyers and everyone who kind of studies and thinks about these areas. We have a government which has said its policy aim is to make Commonhold the default tenure for flatted developments. And there are three aspects of doing that. One is banning the sale of new flats on a leasehold basis. The second is conversion, so enabling existing flats to convert over to Commonhold, enabling, importantly not requiring. And the third aspect is putting in place a new model for Commonhold developments. I'm going to speak to the first and third of those. I'm going to leave Philip to talk about conversion, and Siobhan McGrath won't be too surprised to hear he's going to talk about dispute resolution. So I touched in the paper that I gave on Tuesday, some of you would have heard, I touched there on the ban on the sale of new flats that's on a leasehold basis that's contained in the draft Commonhold and Leasehold Reform Bill. And it is intended to operate in tandem with the ban on houses on a leasehold basis that's contained in LAFRA, but not yet in force. And it's intended to apply to new flats when the ban comes in force. So that's new developments, but also conversions of existing buildings. So any new flat that comes up for sale. The distinction between a house and a flat is a notorious one. I think it's 5 times it's been to the House of Lords or Supreme Court to identify what constitutes a house, and the Minister has said that these two bans are going to be brought into force at the same time. So even though they're running on very different timetables, it seems the intention is that they both sit there until they can both come into force, and collectively they will ensure that all residential properties are sold either on an ordinary freehold basis or on a Commonhold basis. There is a government consultation on the operation of the ban that's still open. It's open until the 24th of April. And there are some key issues within that consultation that will really determine the timescale that we're looking at for this shift towards Commonhold. Because we could be looking at something that happens relatively quickly, or we could be looking at something that happens in quite a slow time frame. So that's one of the things that kind of exercises my mind. So there is a question over transition arrangements. So how long will existing developments be able to sell leasehold flats for after the ban comes into force? And there's a question of how the ban will be introduced. So is it going to be done slowly in phases? And if so, how will those phases be determined? Or will there be one big ban, one date by which all future flats have to be sold as Commonhold? And there's also a significant question as to what exemptions may be made to the ban. I think the one that's flagged in government's consultation is a possibility that some retirement developments might need an exemption. So there's no suggestion that all age-restricted housing would be covered, but some developments where, for example, significant care, social care is provided, it's been suggested, may not be able to operate on a Commonhold basis. It would be interesting to hear from those from other jurisdictions as to how that form of housing is dealt with in your countries. The Minister has also said, I think quite notably, that the new legal framework for Commonhold could come into force before the ban on the sale of flats comes into effect. So it could be that we have a period of time when flats are able to be sold on either a leasehold or a Commonhold basis. If that does indeed happen, I think there are interesting questions as to what the consumer response is to that. If the consumer has a choice as to the legal model on which to buy their property, or will it even be in consumers' minds? So that's all I want to say about the ban on the sale of leasehold flats. And I want to move to say a few words about the new legal model for Commonhold that's contained in the draft bill and is based, as Helen indicated, on the Law Commission's 2020 reports. Those of you from the UK will know that Commonhold isn't new. It was introduced in 2002. Legislation came into force in 2004, but it hasn't taken off. Only or fewer than 20 Commonhold developments exist. The legal model is certainly not the primary cause of that lack of take-up. There are lots of vested interests. Here, if you're a developer and you have a choice, do I sell a flat as a leasehold and keep some nice income streams, or do I sell it Commonhold and not do so? The choice is a fairly obvious one for most to make, not all. And there's also an inherent conservatism within the property sector, which is understandable. If you have all of your precedents there to develop a site using leasehold, then there's no incentive to redo that work on the Commonhold model. So there are various reasons why Commonhold hasn't taken off. But undoubtedly, one barrier is the fact that the legal model we have is too inflexible to deal with the kind of large mixed-use developments that we increasingly see today. So the aims of the new model, in essence, are first of all to ensure flexibility. So to reach a stage where anything you can do with leasehold, any type of development you can build leasehold, you can build as a Commonhold. And also to ensure that that Commonhold system works for all participants, whether they're developers, mortgage lenders, or owners. And I'll just say a few words about the aspects of the new legal model that are particularly significant for developers and owners. So as far as developers are concerned, one key issue they have is the need to build in phases, and the uncertainty they will have at the outset of a development as to what geographical scope that development will have, because those are decisions they will make along the way, depending, for example, on how well or otherwise the units are selling. It is possible under the current law to build in phases, but it's not very flexible in that respect. In particular, once the developer sells part of a development or sells the first unit in part, there is a statutory list of developers' rights they can retain, but that won't give them the same flexibility they have in leaseholds. So under the new legal framework, developers will be able to keep any rights that they want to keep, but the focus will be on their appropriate exercise of those rights. So if they exercise them for purposes which aren't legitimate for continuing with that development, then the Commonhold unit holders will be able to go to the tribunal to complain about that, for an adjudication on that. I touched on Tuesday as well on the idea of permitted leases in Commonhold. So at the moment, if you're a developer, you get your planning permission that tells you have to have X number of, or X proportion of shared ownership leases in your development. That blocks Commonhold because you can't have them. There's also provision for Islamic finance based, or Islamic finance lease-based schemes for those to be permitted in Commonhold. So that's on the developer side. As far as the buyers are concerned, the real restriction in Commonhold at the moment is that everyone votes and pays on all issues. So if you have even a fairly simple mixed-use development with a couple of shops at the bottom and residential flats above, if, say, the shops want to improve the car park, they want to improve security, they need a vote which is supported by the residential owners, who will then also have to pay for those improvements, even though they won't benefit from them. So there's an obvious risk there of kind of deadlock. You're not going to kind of vote to pay for things that aren't going to benefit you. There is limited ability under the current law to allocate different costs to units in some circumstances, but no ability to restrict votes on issues to particular users. So one of the key aspects of the new legal framework is to allow there to be sections in Commonhold. So essentially a separate administrative areas, so that, for example, in that block, the commercial units could be a section, the flats could be a section. If the commercial units want to pay money to improve security and improve the car park, they can vote and pay for that themselves. If the residential owners want to pay money to refurbish the common parts, they can vote and pay for that. So they're kind of self-managing. If the roof of the block needs replacing, then all of them, commercial and residential, would vote and pay for that. So essentially replicating the kind of scheme that is perfectly common in leaseholds, and enabling that to be scaled up. And the final thing I'll talk about is minority protection. So Commonhold works on company law principles. Decisions are made by votes in the Commonhold Association, and there is a concern of the so-called tyranny of the majority. If you're sitting there happily in your flat with your beloved dog, and your neighbours vote to ban pets in the Commonhold, what do you do? Well, the answer under the new legal model is twofold. One is it's a lot harder for them to do so, because a vote to change those rules would be a special resolution rather than an ordinary resolution. And the second response is, once again, you knock on Siobhan's door and you ask the tribunal to adjudicate on the issue on the basis it's had a particular impact on you, and the judge could, for example, say, well, the judge could say that change can't be made, or could say, well, yes, that change can be made, but you are exempt from its effects. As I said, that was the last thing. I'm going to say two other things as my real last thing, which is a couple of kind of myth-busting issues. One is often hear concerns or criticisms that people can't manage their blocks, Commonhold is putting them in an impossible position. But Commonhold isn't about self-management. The expectation is that in most instances, the Commonhold Association will appoint a managing agent to run the block themselves, as a freeholder may often do. The difference being that the Commonhold owners will be able to decide who that manager is, and will have, as it was has been described, they will have the power of hire and fire over the managing agent, so it gives them more control. And the second is, again, it's often put in terms of, well, most people just want to close their front door and forget about everything. And I think, but that's fine. I'd love to do that at home, but I've my little terrace house. I've got a damp patch on the wall, various other things. I can't close the door and forget about them. And actually, nor can you as a leaseholder, whether you've got an external freeholder or if you're a Commonhold unit owner living in the block. None of us can just close the door and forget about what's happening. And the experience that leaseholders have had is that they can't forget, but also they can't do anything about it. So what Commonhold does is at least enable them to take control and actually do things to resolve the problems that they'd like to close their door against. That is all I will say, and I'll hand over to Philip.
Thank you. Almost just for giggles because it's April Fool's Day. And just to watch your face, I would suggest that there's a long future for leasehold. I mean, first of all, we're not talking about commercial leases. All the commercial leases are unaffected. But I mean, the leasehold star, I tell you, is not going to go supernova and turn into a black hole, into a common hole, into which all leaseholds are sucked instantly. It's going to continue burning like a red dwarf star for decades and decades to come. And it's easy when you think about it. We'll maybe get a bill late 26, maybe early 27. No one really knows. There's so much uncertainty in the world. Who knows what the parliamentary timetable is? Who knows when it passes and we get an act? And of course, it won't come into force immediately. We get an act. Traditionally, with enfranchisement, bills are lost by a general election. So the first Enfranchisement Act we have is the 1920 Places of Worship Enfranchisement Act. That was lost multiple times because it's based on a report from 1888. And it was lost in general elections. It was lost in the crisis of 1912 with the Parliament Act. It was then lost with the First World War. The Leasehold Reform and Urban Development Bill of 1992 was lost when there was an election, which is why we have a 93 Act. There was a 2001 Commonhold Act, which was lost with an election. So we could easily have an early general election, and it'll either get lost or it'll get passed in an unamended form in wash-up like LAFRA, which is one of the reasons why LAFRA is not in force. If none of that happens, it will then be brought into force by whoever wins the 2029 general election. Not everyone, I suspect, without being political, has the same degree of interest in this. Not everyone is so immune to the blandishments of big business who have literally no interest in this going through. So you can't assume that this will ever get brought into force. Let's assume it does get brought into force. It'll then have to be brought into force for new developments. The new developments will sort of begin under the regime in the 2030s. Maybe you might get some Commonhold units on sale, maybe 2035 or something. I certainly have no intention of being in practice in the assuming I manage to make it that far in the 2030s. There are 200,000 roughly new builds across the UK. Of course, that includes Scotland and Northern Ireland. And it includes all the houses, which of course probably won't be Commonhold. So the number of Commonhold units will be quite slow if they trial it with new developments. In the meantime, LAFRA probably will get brought into force. There'll be a rash of collectives of properties between 25 and 50% non-residential. And then we get to this point, which was a bit that Nick did want me to talk about, which is about conversion. And as I think most people know, that the very, very simply, the conversion scheme is that you collectively enfranchise first, and then there's a second stage to go to Commonhold, which is optional. You don't have to do them at the same time, so you can go the conversion stage on a previously enfranchised block. But at risk of going into one of the things we were going to talk about later is, well, is there any incentive? It's like developers. If you are a leaseholder run block and it's working well now, why would you convert? It takes time, it takes organisation, there's some money because there will be costs of it. You have probably the exhaustion of having done it the first time around. You run the risk of ruining something which is working well. ruining the good thing. You've got the risk of the unknown. Why be a trailblazer? There are potential problems with the price paid on subsequent conversions of non-participating leases in Commonhold, which may put at risk the investors who paid to support the first collective, and those investors may be people who live in the block who've acted as the white knight. So I suspect that there won't be many blocks which will bother to convert, at least in the short term. The only thing I think which will push blocks to convert who've already collected in the past is if you get a two-tier market emerging. And the two-tier market will only emerge when there's a body of evidence of newly sold Commonhold units that they're worth more than the equivalently sold flats, and that will take quite a long time, I would suspect, to become provable, basically. I mean, people might suggest it, but it'll take a while before there's the real evidence of it. If the block is poorly run, then the last thing you want to do is convert it to a Commonhold. What you want to do is to do a second time around collective to boot out the group of leaseholders who are running it badly and to replace it with yourself. The last thing you want to do is sit around a table with them. So if it's a badly run block, under no circumstances convert it to Commonhold, because you'll never be rid of these people. What you want to do is to get a little group of 51 or 52% of the people that you agree with and get rid of the people you don't agree with and exclude them permanently from power. So I don't think you'll get much conversion. Sorry.
You've broken my heart. Carry on.
New collectives which are going through at the same time, I think that's a bit more difficult to say, because once you've got the collective going through, you've already got the money together, you've got the group together, you've got the enthusiasm. You might say, and if people are enthused about the Commonhold because they've been listening to all of the views that leasehold is irretrievably futile and toxic and broken and terrible, then that enthusiasm may cause you to say, yes, well, since we're all together, let's only do it once. And you can see the logic. Let's convert straight to Commonhold. So I think new collectives in the new regime, I think it's much more likely that some of those will go to Commonhold. And a lot, I think, also depends on size, because I think a lot of Commonholds will be small. There's a lot of it's all very interesting and very important for big developments that you have sections, all of the changes in the Act which allows developers to develop in phases. But I'm not convinced that most Commonholds will be like that. A lot of flats now are 2 up, 2 down, 4 up, 6 low rise. And if you've got a mixed use development, I mean, for example, I've just done an opinion, has nothing whatsoever to do with enfranchisement. It's about issues with the land use, but a potential infill development of about 100 units. And obviously the planning consent is, it's about 30% affordable housing, mixture of tenures, but also a mixture of units. So mostly houses, but there'll be some flats. If I were the developer, I would just set up very small Commonholds. A little Commonhold for this little block and a little Commonhold for this little block. And they'll run very easily, and they would run under the current law, to be honest. And I probably, because I don't think there's any reason why you can't do this, I would run the estate roads by the way it's done now. Put a rent charge scheme in. There's nothing which says you can't impose a rent charge on a Commonhold unit because it's a freehold, unless they change the bill. And so actually a lot of Commonholds, I think, will be small and easy to run and almost a sort of what was all the fuss about. I've said enough. I'll hand over to you on this.
Thank you very much, Philip. I am aware that many of you will have never heard of the first tier tribunal property chamber. It's very odd, but I am aware that that is the case. And we are very like a court, but also a tribunal. We have judges, we have expert members who may be surveyors, building safety experts, environmental health officers. We have a very wide jurisdiction, which includes Building Safety Act, Commonhold and Leasehold Reform Act 2002, Land and Act 1985, Housing Act 2016, Housing Act 2004, Tenants Fees Act, and the list goes on. And any rumours that I am seeking to take over the world are just completely and utterly refuted. I'm an accidental person who just seems to have these jurisdictions that keep coming along. But you may wonder why I am slightly separate from this just
Intentional.
it wasn't intentional, but of course it does demonstrate the independence of the tribunal. We are independent from lawyers, from academics, from the Law Commission. That doesn't mean that we don't take any notice at all, but that independence, it was accidental. That independence is illustrated by this empty chair that I thought Helen was going to say. Because as Nick said to me when he asked me to speak today, he said, Siobhan, you'll be able to talk for 10 minutes or so, or 7 minutes on dispute resolution, won't you? Well, I think I can just about manage 10 minutes. It's really difficult because I actually usually talk for a much longer time, but I'll squeeze it in. The importance of dispute resolution in property cases cannot be underestimated. It is as simple as that. And that does not mean that there will always be conflict. But if there is an efficient, proportionate, relatively speedy way of resolving disputes, there are fewer disputes. It's just one of those things that is logical. If a person actually is out to make trouble, they will take advantage of the fact that it is very difficult to obtain redress in a sensible way. So I think it is absolutely vital. One of the difficulties, and I will look at difficulties in the next few minutes as I speak, is at the moment in the UK and in England in particular, actually in each of the countries, the complexity of dispute resolution providers is sufficient to stop people seeking sensible redress. So we have the courts, we have the tribunals, and very few people can understand why there are, including me, why there are two bodies when there should perhaps just be one housing court. That is being considered several times very seriously and is being rejected. But so there's the courts, the tribunals, and the ordinary person. I don't mean that in a pejorative way at all. I mean a person who's getting on with their lives, minding their own business. Why would they spend time trying to find out which place they should apply to? There are alternative dispute resolution providers. There's mediation, conciliation. There are ombudsmen, there's a property ombudsman, the housing ombudsman, the social housing ombudsman. There will soon be a private sector ombudsman. And then there are regulators. So if you, as a person, have a housing difficulty, because it isn't always a dispute, it starts as a difficulty, would you know where to go? It would be extremely difficult. And that is made worse by the fear that if you make the wrong choice, you are stuck with that choice. And you can't change to a different pathway to get that resolution. And then the third difficulty, is the complexity of the law. If I may say, Nick, I think that the bill is admirably straightforward. I think it is a very easy read. It is clear what it's trying to achieve, and I think it is excellent. The difficulty is, even with very clear legislation, in property, there's always something else at play, and it might be other legislation, other regulation, which interacts with that new piece of legislation. And that complexity is extremely difficult to handle, I would say, without an expert body to be able to assist in achieving that resolution. Furthermore, there are inbuilt challenges for leaseholders or those who live in a Commonhold going forward. First of all, there is the very straightforward, simple challenge of living communally. And that really does cause difficulties. So we already have something which isn't really the freeholder and the leaseholders. We have collective enfranchisement, so you have governance by the leaseholders themselves. We have the right to manage. And unfortunately, in the tribunal, some of the most intractable cases we see are where that has happened. There's the jam factory litigation. Got themselves into a pickle. And this is one of those new warehouse developments in London. where an application was made for, I think we actually had to decide, a collective enfranchisement. But of course, not everybody was a participating leaseholder. And there are factions. And one faction brings cases against the other faction. So the non-participators applied for the appointment of a manager to take over the management from those who had collectively enfranchised. And this litigation went on and on and on, and they were all very difficult. I remember getting correspondence once, I think there were about 6, I don't know how many leaseholders there are, say there were 30, and one wrote in and said, we do not want to appoint a lead person in this case, we all want to be able to speak. And I said, okay, you can do that, but I want 30 application fees. And then they went away again. But so communal living, communal working together has its own challenges. There are also, in particular, and we have seen this with the Building Safety Act, which came as a consequence of what was found out, what was perceived as a result of the Grenfell Tower fire. There can be inherent problems with construction. And one of the challenges going forward with many leaseholds and commonholds will be obsolescence. How much should be invested to maintain this building? It is a real problem which those who are living communally and have probably the most significant financial investment they will make in their lives, they have to know how to deal with these questions. And thirdly, it goes back to that communal living, different views on priorities, different views on standards of repair, different views on including improvements to a property. And resolving that is extremely difficult, and it cannot easily be dealt with by a tribunal. It's not suitable. So what do I say the essentials for effective dispute resolution are? First of all, there must be a clarity of those pathways I was speaking about. People should be clear. You go down this road, this is what you can expect. But also, there should be a possibility of taking a pathway and changing over to another one. To achieve that, I would say we need a single point of engagement in property, housing, landlord and tenant disputes, where the, I've said this so long, I say it, where the punter, for want of a better description, engages and is assisted to understand their options. That might include being given advice. It might say try mediation first. It might need a tribunal adjudication, but the ability for those providers to have sufficient communication so there can be a porosity between them. I think that's absolutely essential. Whoever is providing the dispute resolution must provide clarity of process so that expectations are realistic and can be managed. And the people who are providing the dispute resolution, I say, should have expertise in the subject matter, not just in the law, but in the subject matter. They have to understand how buildings work. They have to understand how property markets work. That is something we try and achieve in the tribunal. They have to have expertise in case management. A case is not just the final hearing. I think you'd agree with this, wouldn't you, Philip? It's how it gets there. Mm-hmm. It is really important how it gets there. For example, again, looking at Building Safety Act cases, we case manage them to death. There's been quite a few practitioners who've complained about this, but it has worked. We bring parties in, we say we must have a position statement, and we narrow the issues, and we keep on and on at this. So, we also, for essentials for effective dispute resolution, is having the full engagement of the parties. There is a tendency in legal process for parties to sit back and wait till they are directed to do something. My preference is an appreciation. This is my case, and it is my duty, and it is my desire to make the best case that I can, with or without professional representation. So, what are the opportunities presented by Commonhold? There are some. There's quite a few. First of all, I think there is a real opportunity for the setting of a culture. And one of the problems with collective enfranchisement, right to manage, isn't just that people are excluded. It's because it is simply taking over what is almost an adversarial relationship, us and them. That is different for Commonhold. It should be possible. It should be a requirement of Commonhold, I say, that people enter into Commonhold in the proper spirit of we are in this together. And I think that can be done by peer pressure. It can be done by the fact that it has happened and has succeeded in Commonholds as they get set up. And there should be that ethos, which is included in that culture of cooperation and self-regulation by consent, almost peer pressure. We do this, we pay our charges because that's what we do, because we all know it's for the benefit of each other. It isn't perfect, but it's a very good start. And that includes a recognition that there is no perfect answer to a property dispute. There is no perfect answer. And what I say that people need to learn, and it happens in mediation, that mediation magic, that shifting of the mind to what is it I really want to achieve. It is understanding and embracing compromise. And I think that Commonhold really does present that opportunity.
Fantastic, thank you very much. Right. So, some questions, which I will slightly amend, just half the answers are being given. But anyway, from each of you, what do you think the day-to-day reality will be for those living in Commonhold blocks? How will it differ from leasehold? And the second part of that question is, do you think that Commonhold has been oversold? So I don't think that I can guess your answer to the but fire away.
Well, I mean, on the second one, I do worry that Commonhold has often been put forward as the solution to problems in leasehold without being examined in itself. And I think there is a real piece of work to be done in ensuring that the expectations people have are reasonable, and agree with what Siobhan said in her talk, that shift from us and them to we and ourselves, it does mean something, and people buying into Commonhold need to understand what it is they are buying. I think similarly, people buying leasehold at the moment need to understand what they're buying, and they don't. And Commonhold is easier to explain than leasehold, not least because it's a uniform system. So to some extent, how Commonhold blocks run would be the same in Manchester, Southampton, Exeter, anywhere, rather than individual leases. Commonhold isn't a panacea, and I worry that some of those who campaign for it do see it in that way, which goes back to Philip's reference to the let's end the feudal system, which is the political slogan, which I've winced at for 10 years and still wince at every time it's said. And so there is a need to actually explain to people what Commonhold does in fact involve, and ensure that they do understand what they are getting into. So some of the concerns people have, for example, around increasing service charges. Well, a light bulb isn't any cheaper to put on because it's Commonhold rather than leasehold. Electricity costs the same electricity is going up. So service charges aren't suddenly going to come down because it's a Commonhold block rather than leasehold. But what Commonhold does give is greater transparency into where that cost is coming from. And if that cost is coming because your managing agent is putting up their fees rather than because the electricity prices are going up, you will have the control. You will be able to say, well, okay, we're not going to use you anymore. We'll use someone else. So I think I think Commonhold is inherently a better legal framework. I think it has advantages to it, but I do worry that it might be seen by some as the solution in itself, rather than the starting, the right legal framework to provide that solution.
Your thoughts?
Pretty much the same, because actually, despite the fact I was sort of taking the nick, I mean, I do agree fundamentally. Commonhold is a better way of holding residential units in multi-occupied buildings. And I don't think that you can underestimate actually how important it is that you have uniformity of process. Because one of the problems with most leasehold, you get a new managing agent, and then they spend X amount of money actually reading the leases, if they're good. Because actually most of them don't read the leases, and actually they send out the demands the way they do on all their other blocks, and they've not read the lease and they can't do it. And that gives leaseholders defences. And on this block, actually you don't have to pay for the car park entry phone on this block, but you do on this block, and all of that goes because it's all the same. That's great. On the other hand, and first of all, I don't think a lot of people in the leaseholder lobby understand how slow implementation is going to be. I don't think they understand actually how difficult it would be actually to convert existing blocks. You'll have some enthusiasts, and then they'll find they need to get all of the, more than 50% to engage, and then they will be frustrated that they can't get it. And of course, all of the blocks which are more than 50% non-residential, no conversion at all, you can forget that, which is another reason why leasehold will continue ad infinitum, because there are a lot of blocks which are more than 50% non-residential, and they're right up to things like shopping centres, which have got a couple of flats built on the roof, or a hotel in London which has 2 or 3 penthouses. They're sort of 80-90% non-residential. There's no way they'll ever be Commonhold. But the most important thing, I think, is Nick's point. People think the service charge will go down. In fact, it will go up. It will go up because most blocks run with inadequate reserve funds, and one of the key things about Commonhold is that they must run with an adequate reserve, which means people have to pay for it as they go along, and they won't like it. So almost everyone who converts to Commonhold will see their service charges go up, and they'd much rather that didn't happen, because human beings put their heads in the sand, just think, oh well, yeah, the roof might need fixing, but it'll be 20 years time, I'm going to sell in 5, so let's forget it, I don't want to pay. So all of that goes out of the window. And you've still got the problem with lack of flexibility. If you own a house and you lose your job, then you can put off painting the outside. It'll last for another year or two while I find another job. If you live in a block of flats and they're going to paint the outside and they need the money, you don't have that flexibility, and no system will ever change that. And I think my final point actually about service charges and so on and expectations is, I have no proper evidence for this, but I think that the majority of people who own, particularly the sort of lower value flats or lower to mid value flats where you get service charge disputes, the majority of people who are owner occupiers of those flats and who go to the tribunal have never owned a house. And because they've never owned a house, they've never had to ring up someone. I've got a tile off my roof, came off in the wind a few weeks ago. It's unbelievably expensive because the roof is just too tall for a ladder. I will need a cherry picker, we'll need some scaffolding for that. And if you understood, because you'd owned a house, how expensive it is to actually maintain a house, then you wouldn't then go, this is ridiculous, the roof costs £1 million, and then you have 100 flats, that's 10,000 a flat. Sounds pretty reasonable actually to me. But to the leaseholder who's never owned a house, it sounds terrible. And you can't cure that with Commonhold either. So unfortunately, I think there's going to be a huge disappointment.
No, you can't say that, Philip. I need the work.
They've taken away all of the rights to challenge everything, which is the other thing they'll find out.
I don't think it has been oversold. I think that it has been misdescribed, possibly. I agree with what Philip has said about the fact that perhaps the expectation is everything will be fine, everything will be less expensive. So I think it's been missold. But I think there will be a difference, and the difference will be that I think not only will there has to be more transparency during the time that people are living in the property, has to be there right at the front, and we were discussing this earlier, weren't we? That the fact that people, I think it was Nick's phrase, they don't buy a lease, they buy a flat. And that's what they buy. And they don't care what the lease says. And in a sense, I would hope that in Commonhold, they will be told, well, this is what will happen. And you'll be expected to agree this. You will be expected to, as I said earlier, that compromise to discuss it sensibly. So I think there's and the other thing that goes out, I think it's more of a, if you like, a not that I am a psychologist or anything, there will not be so much us and them. So there is a completely misplaced, in many instances, distrust of landlords, no matter how good and fair they are, and that mistrust will go. There are some very poor landlords, there are some appalling leaseholders. That's life. But there is that inbuilt mistrust. They have all the value, which of course also isn't true, but that's how it's perceived. So I think that difference would be there too. Oh, do you look at that face?
Well, I was thinking about your powers, you see, because
My powers.
the powers of the tribunal. Because I think the tribunal is key to this. Because actually, the most important section in the whole Act is in the bill, clause 97, dispute resolution, and the regulations we haven't seen. Because transferring all jurisdiction to the tribunal, build your empire. I mean, I would say, because one of the flaws, if you like, of Commonhold is that the Commonhold Association is a company, and I've done cases like this. If you take away all of their rights as leaseholders, so it's very difficult to challenge anything which is described as essential expenditure. If it's voted through properly and it goes on the budget and it's as I say, it's not optional, effectively you can't challenge it if it's properly voted through. So we'll all become really experts in the company. And I've done this is happening already. So first of all, you say there wasn't adequate notice given of the meeting. Section whatever of the Companies Act wasn't complied with. The directors are not validly appointed. Such and such was allowed to vote, but they're not actually a member because although they bought the unit, no one has registered them as the member. So therefore their vote is not valid. And then the chair rejected my objection to that and refused to call a poll. That's a breach of the Companies Act, and so on and so forth. And you can determine all this, but
I think this is why somebody who gave evidence to the MHLG Select Committee, who isn't sitting very far away from it, suggested that the tribunal should have a power to dispense with technical breaches as a way of preventing.
But it's not in the bill.
It's not in the bill. It's not in the bill. But
There's no provision in the bill to extend time limits. There's a lot of 1 month statutory time limits for challenging everything. And unless you give the tribunal the power to extend the statutory time limit, then it's out of time, which will then cause lots of disputes about service and so on. But also it will mean people will be frustrated, so therefore they'll go for whatever else they can try for, which is to argue that the thing wasn't valid in the first place. So
all of that is, I agree with everything you've said, and I pale when I think about company disputes. I mean, I did the most appalling case I ever did. It was a cooperative society, but very, very similar to company law. And there were challenges, and I sat double-hatted. One in the tribunal for service charge payability, and the other breach of the contract. And each of the issues was exactly the same. It was terrible. One of the ways I think that we will be able to handle that, and I will go on about this, is looking at disputes differently. And again, however it is achieved, but there must always be a space for a different way of resolving disputes rather than coming to the tribunal. And let's see, I don't want world domination. Well, people look after themselves, but it really has to be going forward in a complex, sophisticated society that people know how to compromise, know how to say, let's stand back and say, what is it that we want to achieve? And it might be that we will have mediation, not mandated, but as something that one would expect everyone coming to the tribunal to try first. Or you could have, in Commonhold, you could have, I described it to somebody else, having elders, people there who everybody trusts to try and resolve a dispute on the ground, there and then. And that is absolutely vital. Otherwise, we'll be too busy, but it's not a very good way of resolving disputes for people who are going to have a continuing relationship.
The next cunning question, we'll start with you, Siobhan, is how do you think, what do you think about the problems of having a block with mixed leasehold and commonhold in it?
As far as dispute resolution is concerned, absolute nightmare.
Fair enough.
No. But also, I think in terms of how it's run, I can see real challenges there. And it is inevitable that this will happen. So far as the tribunal is concerned, we will just have to handle this. And transition, as anybody knows, when change is introduced, the most difficult part is the transition. And that is something that will have to be managed, and it can be managed by introducing different parts of the bill if it becomes an act slowly and logically, so that people get used to it, have opportunities to rationalise as much as they can. But yeah, it'll be hard work.
Have you any thoughts on that? The lawyers are going to love it. So
Yeah.
I mean, sadly, if you're practicing at the bar or in any form of dispute resolution, then it's very hard to think of any legal change apart from an outright repeal, which doesn't simply generate more and or different work. I mean, in this case, it's probably different work, and I'm not sure it'd be more work really, because there's no
Same people,
no shortage of leasehold disputes. You'll just be sort of rebranding them. I mean, I was smiling, but I suppose I've just been doing this for too long. As a barrister, you just see the worst of people, really. So the cases I see are people, neighbours, viciously squabbling with each other. There's, third-party landlord, everybody hates the landlord, but one person that everybody seems to me who goes to court hates more than anybody else is their neighbour. And you can have, they've knocked down a wall in their flat, they're too noisy, they're this, they're that. Or on a you can imagine on a multi-block, sort of, ever seen 2000 AD, it's block war, my goodness, the people in block A hate the people in block B. The people in block B are misusing the parking spaces, which should be for block A, and block B has got a little faction who control the directorships, and block A really hates that. So, unfortunately, I don't think it's a utopia. I wish people would behave better. And I think there's an education piece which needs to be done, which is about the responsibilities of collective living. And that, just because you want to have a wood floor down doesn't mean that you can put it down without adequate underlay, which is another perennial problem. Because you don't want to spend the money on adequate underlay, despite the fact that it makes life unbearable for your neighbour below, or even moving, into people don't understand. But the reason you can't change the internal layout is because as long as the bathrooms are all on top of each other, the noise of the bathroom floor is fine. But switch it round, and so somebody's bathroom's on top of somebody else's living room, and it becomes a problem. And people don't seem to understand that you can't just do what you like when you live in a flat. And a huge education piece has to be done, I think, to make this work better.
And if I could just say, I agree with Philip about it's the same for the tribunal. We see cases where things have gone wrong. And there are many, many other instances where things haven't gone wrong. You just don't see them, do you? It's very jaundiced view of the world. I would never buy Leasehold. I say to colleagues at work, wouldn't it be nice to live in a lovely little mansion flat somewhere? They sit me down, they give me a cup of tea, they say, Siobhan, you're just not feeling yourself, you don't want to live in this.
I hesitate to ask the question, but would you buy it if it was Commonhold?
Yes, I would.
Thank you.
You may pay me later.
Nick, any thoughts on mixed Commonhold leasehold?
I mean, I agree with a lot of, I think with everything Philip said in his introductory comments. Conversion has, from the outset, been the most difficult issue to try and be solved. And I think it's always going to be easier to set up a Commonhold development from the outset than it is to take an existing leasehold block and transfer it over. I mean, I think that the approach the draft bill takes is probably as good an approach as you can take in terms of trying to integrate the long leaseholders into the Commonhold. So giving them the vote in a Commonhold association on most issues, for example, because that should take away some of the management difficulties, but there are still things we don't know. And I don't think, for example, that the draft bill explains what's going to happen where the terms of the lease and the terms of the Commonhold community statement conflict. So what if the lease says everything has to be repainted every 7 years, and the Commonhold community statement says everything has to be repainted 5 years? It's going to be kind of simple, inverted commas, technical things like that that could be the most difficult to resolve. I also agree, despite my own comments with Philip saying that leasehold is going to be here for a long time, and I don't think I'll ever recover from the image when I gave evidence to the Public Bill Committee of Loughborough, and I said no, leasehold is going to be here for a very long time. I wasn't aware at the time that one of the leasehold campaigner was sitting directly behind me and was kind of holding her in her hand in despair as I said that. But but it is going to be there. Blocks that cannot convert. There are blocks that just won't convert. So we are going to have leasehold and commonhold alongside each other for a long time.
But it is a transition, and Commonhold or the equivalent in other jurisdictions works fine.
Yes.
With the people who are out of Delta.
Yeah.
Really.
Yeah.
I think we should open it to the floor now to see. Perhaps they can cheer you up, Philip.
It's me who needs cheering up after Philip.
Probably right. So, David, do you?
Yeah, I have a question. David Sotell, 39 Essex Chambers. I'm going to cheer Philip up, but in the bad way, because I completely agree with you that actually a lot of leasehold and RTM disputes become company law disputes. Just about who's the director. Oh, I didn't get notice of the AGM.
Yeah.
We're being an action now in the company's course, and as you type this advice with tears running down your eyes, I see the bill and the government guidance promotes dispute resolution. But I have a question possibly for Siobhan and for the whole panel. Is actually company law the correct mechanism to make decision making, to embed democracy and democratic standards into a Commonhold structure? And if it is classic company law remedies the right way to approach it, or should there be a more specialist for dispute resolution for disputes that will rise?
If I am asked, David, I will say it is necessary to. And you read the bill, the draft bill, you can see there are times when it looks like it's verging on common law, but it isn't. But pure common law, a company law matters should go to a specialist forum. And there are ways of arranging that so we could transfer matters on. We are not company law specialists, and we become specialists in too many things. We won't be specialists at all, just like the county board. So I agree, and if I'm asked, I will say we must be able to identify which of these matters require specialist company law dispute resolution.
So I would disagree with you. I would agree with the implicit proposition that you've made, which is that I think the Commonhold Association should be a sui generis, a unique form of body. But if it isn't, then there should be a much more thorough job of disapplying bits of the Companies Act. Yeah. But I do think that the tribunal should decide it, because the same rule does not have to apply for the AGM of IBM to a Commonhold Association, and you should have the power. I think I did suggest this in my evidence to the Select Committee. One thing you could do is you could say that if the company involved is a Commonhold Association duly registered as such, that the tribunal is not obliged by precedent to follow exactly the same line, so that at least you could develop a sort of different strand of companies law.
I don't disagree with that. And on that premise, yes, it would be fine if the complexities of, and they are complex, the complexities of company law continue and apply as a separate code at the same time, then I think we'd have to find a way.
I think what I'd add is that, I mean, the Law Commission, we did consider, do we use company law, do we set up something sui generis? I don't think setting up something sui generis helps because you just create the same issues in a different environment. The issues are going to be around have people have the right amount of notice, have appointments being made properly, for example. If you try and set up a sui generis scheme, you will create those issues in any event. So using company law, I think it is kind of quite pragmatic in the sense that it is something that's there. It's used for right to manage companies. It's used in after collective enfranchisement. So it also has there is experience of use in the same context. But no, I think Philip did make a very good point, giving evidence to the select committee as to whether you do then need to think about what powers the tribunal has to kind of dispense with technical breaches, and also technical breaches of requirements that are not part of company law but are within the draft bill itself.
Okay, I think Sue had a question.
Yes, I'm Sue Wright, University of Oxford. Going back to the title of the panel, The Future of Leasehold, and the general acceptance by most members of the panel that leasehold has a long future. One of the things that concerns me is that there's been so much talk about conversion to Commonhold for quite a long period of time that we've not had a serious conversation about ways in which leasehold needs to be improved to make it better. And it seems to me a lot of what we're gaining through Commonhold are things that we ought to be trying to insert into existing leasehold. And I'm just wondering what your thoughts are.
Yeah, I mean, I'm happy to have a go. I mean, I think reforms to improve leasehold have happened to some extent in parallel with Commonhold. I mean, that was true in 2002, and it's true now with LAFRA, for example, as well as the current. Actually, the current draft bill doesn't do so much with leasehold, but I think there have been attempts to improve leasehold. A lot of that is not in force as yet, but I think it is a completely fair challenge that things that are being done for Commonhold, the question ought to be asked: should they also be done for right to manage and collectively enfranchised blocks? Because while they are different, there are parallels there, and so some of the discussion has been around Commonhold in terms of the need to ensure that directors of the Commonhold understand their responsibilities. Exactly the same applies to right to manage and collective enfranchisement. So I think there is value in looking across the field and identifying what changes could benefit all sort of owner-run, owner-managed blocks, for want of a better expression, and which of them are really things that you can only do in Commonhold.
I think I would agree. I think if you were going to extend it, though, I think you probably have to distinguish conceptually between genuinely leaseholder-owned blocks, which I think you might take to mean where there is 100% participation and membership of the company, which would be the equivalent of Commonhold, down to other blocks, because there are a lot of post-enfranchisement blocks which were enfranchised by a bare minority, and for good or bad reasons they haven't let anybody else in. And there's no real reason why that kind of block should be given, for instance, dispensations from some of the landlord and tenant legislation. But you could, as a quid pro quo, in fact, to encourage participation, you could say, well, if you have 100% leaseholder control, then we will relax some of the Landlord and Tenant Act provisions, which make life so miserable for a lot of leaseholder-run blocks when somebody disagrees. You right to manage, I think, is a flawed scheme at the moment. You could improve the description of the powers and so on of right to manage companies. There are lots and lots of technical changes you could make. But you could also have what I would describe as RTM light. So if, for instance, there's a residential head lease, it's just waiting to be taken over. So why do you need qualification provisions, really? You just have to say that as long as you have a majority of the people who are subtenants of this particular residential head lease, they should be able to incorporate a right to manage kind of company to substitute themselves for that head landlord over the residential parts. There are lots and lots of blocks where you could do that, for example, to give leaseholder control. And that's just one thing. I mean, and on an aim to simplify the law, I've said this lots of times, I would abolish Part 1 rights of first refusal, because they're a complete pain. I mean, it's almost a sort of racket for lawyers. I make a reasonable amount of money advising people on either how to get around them or how to, they sometimes get property for a song. They usually operates unjustly. And if once you've raised the qualifying criteria for collective enfranchisement to 50%, which is the same as rights of first refusal, it's just an old, not very good piece of legislation, and I would simplify things for everybody's benefit by getting rid of it. But I could go on and on. I've got lots of ideas.
I think Sue isn't just talking about where you have owner managed properties, you're talking about leasehold generally. Whether there should be some creative thinking about core terms or something of that nature, so that everybody is living in leasehold property knows those core terms. I know people, really competent people, who come and say, "Oh, I've asked my landlord what this service charge is for, and they haven't answered." And I say, "Well, they have to. And how will I know if I have to pay it?" And I'll say, "Have a look at your lease." He said, "I've got a lease." No, these are fairly competent people. And that can be addressed by getting some more uniformity. But a bit like Philip, I mean, we could talk about this all day, the ways things could be improved, pending the final solution. Pending Commonhold.
Pending Commonhold, riding off into the sunset.
Yes, where everybody's happy. And
sorry, leasehold riding off in the sunset.
Yeah. What's our arm in arm?
Commonhold. Yeah.
Okay, any more questions? Any questions? Right, so
I'll be very brief here. Sorry, Sarah Newt, ex-University of Southampton. I was just actually intrigued by, and I think we're absolutely right about the change of sort of culture, but I'm wondering actually how this is going to happen, given that perhaps we need some sort of public education campaigns, and not least that universities and law schools in particular might be teaching their students about flat ownership. I don't think that many really do, because it's tricky and it's tough. But I think we should be doing our bit, if you like, to facilitate this cooperative, communal. The idea that communal living is a cooperative way. It's not an adversarial way.
Yeah, I agree, and not just universities. It can start earlier than that. The way in which you approach, although I've used it many times, that word dispute isn't necessary. It's a housing challenge. It's a housing difficulty. It doesn't have to turn into a dispute. You get that resolved first. I agree.
I suppose Commonhold, actually thinking about it, helps it, because presumably if Commonhold was the default tenure and there were lots of Commonhold units, then the curriculum for the landlord module would have to change. And you would, because at the moment there's a bit about leases in theory, but unless things have changed since I was at university, you don't really do landlord and tenant law at all. But you would have to do, because Commonhold's a form of freehold tenure. So, and if all Commonhold community statements essentially are the same, at least the basic bits are the same, then you could and probably should teach it, because it would be an embedded feature. So actually that probably would happen automatically.
It is very technical, but the basic concepts that are about cooperation.
It isn't boring at all.
I
was really, you see, Helen sits as a judge. Caroline.
And there must be lots of lovely cases.
I think that if I may to slightly broaden out, because I'm also the current chair of the Property Bar Association, so I do a certain amount of talking to students, and I judged a moot at Leicester and just talking to some of the students. But the one thing I found when trying to encourage students, usually How many want to go to the bar? There's only a minority of hands. How many people want to do property lit when they go to the bar? No. How many solicitors? Who wants to be a solicitor? Fine. How many people think that they'd like to get a seat once they specialise, once you've got your associate status? How many want to be an associate specialising in property lit? No one. And I tell them, I'm sorry to any of academics here, I tell them, no, what you have to understand is that the practice of property litigation is nothing like what you learn at university. It's just, yes, it's tedious and you write easements, and it's not like that at all. It's contract based and you have, disputes and so on. And I basically have to try and explain to them it's nothing like land law. It's just the way it is.
So many years ago, I did some teaching at the LSE on a housing module for housing professionals. You did as well, Carol, and handed it over to me. But the way I did it was I took at the time, how old I am, Housing Homeless Persons Act 1977, and took a bit of that statutory interpretation, all sorts of things, and said, this is an example, this is how precedent works, here's an example, to make it live for people, because it's fascinating, really, really interesting.
Well, I have to say, I brought Yindani with me to my tribunal last week.
Did you enjoy
I
it?
think you felt it. It was more
Did they make
exciting than you thought it would be. In
Yeah.
good and bad ways.
Did they make the right decision?
It actually depends what the right decision was.
Have you decided?
We adjourned it. But yes, so I think we have got to try and make property livelier, and it's very difficult because you can't really avoid teaching some of the basic and concepts that are quite difficult to grasp. Anyway, thanks for that, Sarah. You started something going. Right, any more questions before we thank this panel for a really enlightening. I'm afraid before we go for lunch, I've got just a few things I have to say. I know I did a few thank yous yesterday, but there are, as ever, when you say thank you, you miss out lots of people. So first of all, we'd like to thank the MSPL for asking us to host this and giving us this opportunity to show off Southampton and what we have to offer. So we're really grateful to you. Thank you very much for that. But I also want to thank the members of the People Property Community Centre. I think we've been a great team delivering this. So that's Lisa, Mark, Chiara, now I'm going to find Sarah. Who have I missed out? Dean, of course, and Dina. And you've all been wonderful colleagues, great chairs of panel, and that's the other thanks to everybody else who's chaired panel. I think it's been the best chairing of an academic conference I have ever seen. So thank you, and thank you to all the participants who've made it a fantastic conference. That we've seen lots of things. We started with a look at proprietary estoppel, so a good old-fashioned English remedy. We went through that, but we've had such rich offerings with property discussions in the context of environmental obligations, in terms of technology. It's just been amazing, and global contributions. So that has been fantastic. I hope you've all enjoyed the presentations as much as I have, and you're all taking away great memories of what we've had. I was hoping that Martin would still be here so I could say the food seemed to be for him a particularly valuable memory. So that's good. But I suppose for me, I hope this is worth sharing. Some of my favourite moments of this conference have been really around the level of engagement of people, professors from Oxford, from Cambridge, former law commissioner, engaging with young property scholars who are exploring their ideas, and the level of respect and mutual engagement
that has been absolutely fantastic and exemplary, and that's what I should remember. And I think it bodes very well for the future of property scholarship that we can do that sort of thing. So I think that is wonderful. It's what MSPL does well, and long may it continue to do that. Lisa is probably glaring at me because I've just forgotten to mention the book. So those people who are hoping to contribute papers for the book, we will give you 4 weeks. You will get this all in an email, but there'll be 4 weeks for you to tighten up whatever your paper is in the light of comments or your own experience in presenting, and then send them to us, and we will consider the selection of papers and make our final decision. But thank you. One more, hopefully good lunch, and see you all in a couple of years' time for this. Thank you.
Thank you.
So do you actually genuinely?